Please don't settle. Don't settle too early. Don't settle for the first offer. Don't settle for who you hire. And don't settle before you actually know what your case is worth. Because early settlement doesn't mean resolution. Very often, it just means surrender. I've seen strong cases quietly destroyed, not by bad facts, not by bad law, but by rushing. And once you've settled, there's no undo button. Hi, I'm Brandon Osterbind, and I'm a personal injury lawyer here in Virginia. And today I want to explain why preparing a case for trial, even when settlement seems likely, can completely change the outcome. If you've been injured, this matters more than you think. Stay with me because I'm going to show you exactly how insurance companies push speed and why that costs people real money. Early on, many cases look routine. Liability seems clear. Insurance coverage exists. Medical records support the injury. On paper, it looks like a quick resolution. And that's when people start imagining the end. That's also when mistakes happen. We had a case that started exactly like that. Rear end collision, neck pain, back pain, bulging discs, nothing dramatic at first. Treatment started, life continued. Then recovery slowed down, daily function declined, lifting things became impossible, sitting or standing for more than an hour caused pain. My client's world shrank, and eventually, surgery became unavoidable. That's the moment everything changed. As soon as surgery entered the picture, the insurance company reacted. Not with concern, with urgency. Settlement conversations sped up. Phone calls replaced written positions, offers came fast, but without explanation. This wasn't resolution, it was pressure. And if you've ever felt rushed after an injury, this is why. Instead of reacting to that, we made a decision. We prepared the case as if it would be tried. Every communication was documented. Every medical development was treated as something a judge and a jury would need to understand. Not for leverage, but for proof. We even retained a medical illustrator to create precise visual renderings of the surgical procedures. Not to exaggerate, not to dramatize, but to educate. Those images showed what medical records never can. The invasiveness of the surgery, the physical disruption involved, the permanent consequences. That preparation changed everything. Once it became clear that the case was built to be proven, not hurried, the tone shifted. Resistance softened. Conversations slowed. Positions became reasonable. The case ultimately resolved for over $1 million, not because we chased a number, but because we were ready to prove it. Here's what most people don't know. Virginia law does not require you to rush. In most personal injury cases, you have 2 years to pursue a claim. That time exists for a reason. Injuries evolve. Treatment takes time. The full impact is rarely clear early on. But insurance companies don't want you thinking about that. They want you focused on their urgency, their deadlines, their offers, because speed favors them. Good settlements don't come from cooperation, they come from strength. And strength comes from preparation. So when I say please don't settle, I don't mean that cases should not resolve. Most of them do. I mean, don't trade speed for strength. Don't trade convenience for proof. And don't settle before your case is fully understood, fully documented, and if necessary, ready to be proven. Because long before a case ever settles, it can be quietly damaged by a sentence, by a casual comment, something said too early to the wrong person without realizing how it will be used later. Long story short, do not settle your case before it's ready to be settled. Before you go, I want you to watch the next video in this series. Saying this will ruin your case. This video breaks down the exact things that people say to insurance companies that seem harmless in the moment, but in the end, cost them everything.